Hello friends, this is Dr. Sumiti Ahuja and I am Assistant Professor from Faculty of Law, University of Delhi. Mainly four modes have been identified under the Indian Contract Act, and as I was just telling you, there are discharge by performance, by breach of contract, by impossibility of performance and by mutual consent. If I may briefly tell you about these four and then we can discuss all of them in detail. So, when we say discharge by performance, that I have already told you in the previous slide, that by performance means that you have fulfilled your obligations, you have kept your promises and you have completed your work or your responsibility under the contract. When we say discharge by breach, in one of our earlier sessions, we have discussed as to what breach means. Breach means non-fulfillment. So, in contrast to performance, or if you can say in contradiction to performance, breach means that I'll refer to one party here. So, one of the parties to the contract has decided not to fulfill the obligation under the contract or not to fulfill that obligation as had been decided under the contract. There are remedies provided under the Indian Contract Act for commission of breach, but that we will be discussing in the next session. The third is discharge by impossibility of performance. Now, one we said performance, here we are talking about impossibility of performance. It is not like breach that a party is not willing to perform the promise absolutely or as a whole, or is not willing to perform it in the manner it is supposed to be performed. Here we are talking about impossibility of performance. Due to conditions or due to reasons beyond control of the parties, the two parties, the contract now has become impossible to be performed. That can be due to some factual change in factual scenario, change in subject matter, change in circumstances, destruction of subject matter, etc. And or it may be legal also. In the sense, a new law has, once you entered into a contract, valid contract, a new law has come into picture and that law has made the subject matter or maybe dealing in the subject matter of your contract to be unlawful. So, it makes it impossible to be performed. And when we talk about the fourth most common mode of discharge of contract, we mean that the two parties, like we say consensus ad idem, that is parties need to agree on the same thing in the same sense in order to enter into a valid contract. Similarly, when we talk about discharge by mutual consent or mutual agreement, the parties have mutually decided either to substitute the old contract with a new one, or maybe they have decided to make certain alterations in the terms of the contract, or maybe they have decided that they do not wish to fulfill any of the obligations under the contract, and mutually they have decided to repudiate or terminate the contract without having performed the obligations under it. We will start with discussing in detail the first mode of discharge of contract, that is discharge by performance. Fulfillment of obligations set out under the contract, this is important, set out under the contract. The terms of the contract have to be performed or have to be fulfilled as it is. That is why fulfillment of obligations set out under the contract within specified time and in manner prescribed by the parties to the contract. So, fulfillment of obligations as it is given under the contract within specified time, that is period mentioned within the contract, and in the manner prescribed, that is in the manner which has been prescribed by the other party, which has been mutually decided by the two parties. Liability of parties comes to an end. So, once the parties have fulfilled their respective obligation, they are no more liable to each other under a contract. Remember, again and again I have been emphasizing in our sessions that whenever we talk about contract, we say therein duties are primarily fixed by the parties to the contract. So, once both the parties have fulfilled their duties or obligations towards each other and the purpose has been served of the contract, Thereafter, liability of both the parties has come to an end. If only one of the parties performs his or her obligations, then that party alone is discharged. This party gets right to take action against the defaulting party. Here we are trying to make a small reference to the concept of breach. So we are saying that, see, generally when we say discharge by performance, we mean both the parties are discharged from performance anymore because obligations have been fulfilled. Here we are saying that consider a scenario wherein one party has fulfilled the obligation, but second party commits a default or say refuses to fulfill the obligation entirely or in part, or as the case may be, but not as per the terms of the contract. So in that case, only that party, that particular party which has performed his or her obligations under the contract will be discharged by performance or will be discharged from further performance, and that party will also get a right to approach the court. When we say right to take action, we are saying that party will get a right to approach the court and claim relief against the other party who is the defaulting party here. So discharge by performance can be of two types. First is actual performance, second is attempted performance. Let's see what both of them mean. So the two types of discharge of performance are, as you can see on the screens, actual performance and attempted performance. So when we say actual performance, we mean when both parties have met their obligations, a contract is said to be discharged. So actually has been performed. Both have performed their obligations. Performance should be thorough and precise in accordance with conditions of agreement. Majority of contracts are discharged by performing in this manner. So which means it is the most common mode of discharge of contract. When we say attempted performance, it is simply an offer to carry out contractual obligations. That means one of the party is willing to perform his or her obligations under the contract and makes an offer to perform those obligations to the other party. Promisor agrees to perform the obligations, but promisee refuses to accept it. That is, I am willing to perform my bit, I am willing to perform my obligation, but the other party is refusing to accept that performance from my side as per the terms of the contract. This is referred to as discharge of contract by attempted performance, or what we are also aware of as tender of performance. So one party is ready to tender performance from his or her side, but the other party is refusing to accept such performance. That is what we mean by attempted performance. Now you can see for yourself that how lengthy is this entire concept of performance of contracts, which is given under chapter 4 of the Indian Contract Act, which is spread over sections 37 to 67 of the Indian Contract Act. So for the sake of convenience, I have on the screen divided these group of sections and have tried to make it easier for you to understand that the provisions or the sections 37 to 39 deal with contracts which must be performed. Herein reference is made to the performance of contract, reference is made to tender of performance, reference is also made to a concept called anticipatory breach. We would be getting into details of anticipatory breach as well later in this session itself. One point again I would like to highlight here, that you need to remember that, say for example, two parties have entered into a contract and say one of them dies. So if the contract say was related to sale of goods, then the legal representatives of that person who has died will you can say will substitute that party and will fulfill the obligations under the contract. The law says if the contract provides otherwise, this is what the actual picture is. Or say for example, if the subject matter of the contract is, say I am a painter and I have been given this task, or I have entered into a contract with someone wherein I have to paint a sketch of that person, right? And say something happens to me, and let me not talk about myself, let's talk about third person. So that third person dies, right, and is not able to fulfill the obligation. I just now told you that according to the Indian Contract Act, unless the contract provides otherwise, the person, the party who dies will be substituted by his or her legal representatives. But one exception you have to keep in mind, that is when the subject matter of the contract deals with some personal skill is involved. Like I am a painter here. It's not necessary that every member of my family is a good painter as good as I am, right? So in that situation, in these kind of contracts, the moment the painter dies, he or she cannot be substituted by legal representative. That particular contract comes to an end because it becomes impossible to be performed. The next set of sections you can see on your screens, sections 40 to 45, they deal with by whom contracts must be performed. Generally, our basic understanding is if the two parties who have entered into the contract, they are bound by the obligations under the contract and they are supposed to perform the terms of the contract. Now, what if, say, someone sold me something and at a later date I have to make the payment to that person, but due to some reasons I am not able to make that payment and a third person on my behalf makes that payment, and that payment which has been made by the third person is accepted by the other side, the other party. Once that payment has been accepted, later on no action can be taken against me by the other party saying that performance was not done or obligation was not fulfilled by the concerned party, because on my behalf someone else has already given you that amount of money which you have accepted. So you have a choice, either you do not accept or insist that I should perform the obligation instead of the person who has been either authorized by me or who is trying to help me out. If either you do not accept the performance and insist that I should perform it, but if you have accepted the performance from my side, thereafter you cannot insist on a re-performance from me. Sections 46 to 50 deal with time and place for performance. They deal with things like when time is of the essence of the contract, that is when parties have decided upon a specific time during which or by which the contract has to be completed, contract has to be fulfilled. They are under an obligation to fulfill the contract or the obligations within that time period. Sections 51 to 58, performance of reciprocal promises. Now, reciprocal means that both the parties are doing something in return for each other. When we say performance of reciprocal promises, we are trying to say that if I have promised something to do for you, in return of that you have also promised something to me that you will be doing for me. So, promise in return of promise is what we call as reciprocal promise, right? So, when we talk about performance of reciprocal promises, these set of provisions basically are dealing with as to what if of a situation basically wherein say there is an order of performance according to which both the parties have to act. Say for example, in the contract it has been decided that once I have delivered the goods or I have gotten the goods delivered to your godown, thereafter within a period of 7 days you have to make the payment to me for the goods, right? So, as per the contract, the order of performance is firstly I will have to deliver the goods to you, thereafter you will make the requisite payment to me, right? It cannot be vice versa. So, unless and until I have performed my part of promise, you would not be in a position to perform your part. 59 to 61 talks about appropriation of payments. So, here for example, say there are two parties, one party is the creditor, the other is a debtor. So, say for example, the debtor has taken three loans from the creditor, and on a particular designated date that person, the debtor, returns a particular sum of money. Now, according to appropriation of payments, these provisions basically deal with the fact that when the debtor is repaying a loan, I am not saying particular, but repaying a certain amount to the creditor which was due, how will the creditor use that amount or appropriate that amount or that payment against those debts? That is what 59 to 61 deal with. Now 62 to 67 deals with contracts which need not be performed. Under these set of sections, we would be discussing about the discharge of a contract by mutual agreement or mutual consent. For example, where the parties have mutually decided to terminate the contract or do away with the contract. So we can justify these terms here then, which need not be performed because the parties have decided so. This is one of the examples. Let's move on. After discharge by performance, let's move on to the second category or second mode of discharge, that is discharge by breach. Breach means refusal to fulfill obligations under a contract. Refusal. Performance was to fulfill obligations under a contract. Breach is refusal to fulfill obligations under a contract. Remedies in case of breach of contract are provided under, there are three set of remedies, we will be discussing them in detail in the next session, but just to let you know briefly. So the remedies are in three sets. First set of remedy provided under the Indian Contract Act itself, Indian Contract Act of 1872. The second set of remedies is also provided under the Specific Relief Act of 1963, and the third set of remedies is common law remedy. Now breach is also of two types. We had just discussed in the previous mode of discharge, discharge by performance. That is, discharge by performance is also of two types. Basically performance is two types, actual or attempted. Here we are saying breach is also of two types, actual breach and anticipatory breach. Now when we say actual breach, we mean that failing to perform an obligation when it is due. That means if today is the designated day when I am supposed to deliver the goods at your place, at the place which you have informed me of, right. So today is the day, and on the due date I refuse to make that delivery of the goods and I refuse to fulfill my obligations under the contract. This is what we refer to as actual breach. That is, on the due date if you refuse to fulfill your obligation. Now for example, failure, this is the exactly same example I was telling you, that is failure on part of seller to deliver goods on time, or if the goods are delivered but do not meet the contract's quality or quantity specifications. Not expressly, but this concept of actual breach can be seen under the provision of section 38 under the Indian Contract Act. Now moving on to the next type of breach, that is anticipatory breach. Anticipatory breach is also known as breach by contradiction. Now say for example, exactly 1 month from today we have decided, the two parties have decided that say for example, I will be performing my part or my obligation under the contract, or I have to fulfill my obligation at exactly 1 month after from today, and say 1 week from today I tell you that see, I would not be in a position to fulfill my obligation as decided under the contract. That is, in the contract it is 1 month from today, but after 1 week from today I am already informing you, even before the due date has arrived, much before rather the due date has arrived, I am already informing you that I would not be in a position to perform the obligation, right. Now in such a case, the party to whom this is being informed, that is the other party who has been informed that this one, the first party, would not be in a position to perform the obligation on the due date, that party has two options. First is fine, you are not in a position, you would not be performing your obligation under the contract, fine, that means it's a breach, or terminate the contract there and then, right. And the second option which is available with this party is to wait till the end. It is to wait till the time, that is from 1 month from today, wait till that date and see, maybe this person is now or at a later stage willing to perform the obligation. So after 1 week I am saying I would not be in a position to perform, but say just a day before the due date I say, fine, I have taken care of everything and now I will be able to perform my obligation. But just remember one thing, if the party is choosing to wait till the designated date, or even if that party decides to terminate the contract on getting the information, anticipatory information about the breach, the party, whatever option the affected party chooses, it is important that the affected party informs the other side that what option is being exercised. And this concept of anticipatory breach again is not expressly mentioned under the Indian Contract Act, but it has been incorporated under section 39 of the Indian Contract Act, and it says, it basically says that when one party prior to arrival of defined date for performance announces that it cannot or will not be able to perform material part of contractual obligation on the specified date. Thereafter what happens, the two options, I have already told you about those two options. Now before we move on to discharge by impossibility of performance, I would first emphasize upon discharge by mutual agreement or mutual consent, because under the concept of discharge of contract, impossibility of performance, or what we call as doctrine of frustration under English law, is one of the most important aspect under this topic. So it needs a little more time to discuss, because we will have to cover the grounds of frustration, we will have to cover the exceptions to it and certain case law, so that will consume our time. So let us first complete this another mode of discharge, that is discharge by mutual agreement. It says parties may mutually agree to. The moment we say mutual, it means that both the parties have collectively decided to act in a particular manner. So parties may mutually agree to firstly substitute the original contract with the new one. That is, the party may, one of the parties to the contract may be replaced by some other party. That is also one of the examples of novation, right, which is laid down under section 62. So there are three concepts which have been laid down under section 62 of the Indian Contract Act, which is novation, alteration and rescission. Let us see what all three of these terms mean. So when we say novation, novation itself, see, in law you need to understand this thing, that most of the times you will get the meaning of a particular word from that word itself. So moment we say novation, novation means new, something new. So when the original contract is replaced or is substituted by a new contract, it means novation. So there is, the parties are under no obligation now to perform the original contract, because that original contract has come to an end now. They are now under an obligation to perform the terms of the new contract. Now when we say alteration, alteration does not mean that you are making very major changes, you are just modifying the entire contract, because if that thing happens it will amount to novation. If you are making slight changes in certain terms of the contract, slight modification under the terms of the contract, that amounts to alteration. So changes in terms of the contract. So the third concept or the third manner in which discharge by mutual agreement can take place is what we call as rescission. So which means rescinding of contract. Rescinding of contract means that the two parties have mutually decided to bring that contract to an end without having performed the obligations under the contract. Now under section 63, a concept of remission has been highlighted, which is lesser fulfillment of the promise made. That is, maybe I owe you a debt and say that debt is of say 10 lakhs, right? But on the, just say on the due date or around the due date, I inform you that, see, I would not be in a position to pay that much amount because I don't have. I have exercised, utilized all my means possible, but I would not at all be in a position to give you that huge an amount from, because that amount is too huge for me to give on that due date. So I propose to, not propose exactly, but I convey to you that, see, at max, if I utilize everything I have, I use everything I have, at max I will be able to give you 6 lakhs. Now remission means, as I said, lesser fulfillment of the promise made. So you accept that thing and you say, okay, fine, give me 6 lakhs and that's okay. The obligation is fulfilled from your side, it is fulfilled, done, you have done your part. Now it means, so once at my request, if you have accepted 6 lakhs instead of or in lieu of 10 lakhs, once you have accepted that lesser performance, you cannot later on insist on getting the remaining 4 lakhs. This also incorporates the doctrine. I have already explained the concept to you, but it is also referred to as doctrine of accord and satisfaction. Doctrine of accord and satisfaction, which means lesser fulfillment of the promise. You are proposing to perform partially perform the promise and the other person is ready to accept that much performance, right? So it is doctrine of accord and satisfaction. Or say, maybe for your purpose, I can continue to, I can leave this thing here, accord and satisfaction. So it will help you. Let's see what is next. Next, now we are coming to the fourth most commonly known mode of discharge of contract, that is by impossibility of performance. You can see on your screens I have specifically mentioned section 56 part 2. Now, because section 56 part 1 deals with void agreements, because it says agreements which are impossible to be performed from the beginning itself. So those agreements, they are related to subject matter or performance of something which is impossible, right? So that part 1 deals with void agreements. So for our purpose, wherein we are referring to discharge by impossibility of performance, this portion is relevant for us, which is 56 part 2, which states contract to do an act afterwards becoming impossible or unlawful. Now it says afterwards. Once you will distinguish between part 1 and part 2 of section 56, or you will read it carefully, you will see that 56 part 1 uses the term agreement, whereas 56 part 2 uses the term contract, because section 56 part 1 deals with what we call as initial impossibility. That is, from the beginning itself the act is impossible to be performed, right? So that is why the term contract has not been used. It is known as an agreement and it is void in nature. So in our sessions related to void agreements, we had made a reference to that. So under section 56 part 2, it says contract to do an act afterwards becoming impossible or unlawful. That means, why contract? Because when you had entered into it, it was a valid contract, absolutely valid, performable contract, but now the situation is such that due to factual changes or due to change in law, the performance of that obligation under the contract has become impossible. You cannot perform that now, right? It says a contract to do an act which after the contract is made becomes impossible, first becomes impossible, or by reason of some event which the promisor could not prevent, unlawful, it becomes void when the act becomes impossible or unlawful. So, 56 part 1 deals with void agreements, whereas 56 part 2 is dealing with void contract. It is void contract. Why void contract? Because it was a valid contract when made, but due to supervening events, supervening impossibility, change in circumstances, etc., it has become impossible or unlawful to perform the obligation, right. So, that is why a void contract, because after the contract was made, it became void. Section 56, as I said, this is dealing with part 1 of section 56, and supervening impossibility is part 2 of section 56. Initial or pre-contractual, that is when the contract itself, when you are that agreement itself, because when you have made that agreement from the very inception, that act was non-performable, impossible to be performed. That is why this term pre-contractual has been used, because contract has not come into force at all. Supervening impossibility, because it is post-contractual. Contract was made, thereafter the impossibility came into picture. And factual and legal impossibility. So, basically what I am trying to tell you here, that section 56 can be classified into two, part 1, part 2. So, part 1 deals with initial impossibility, part 2 deals with supervening impossibility, and further part 2, which is supervening impossibility, can be divided into two, that is factual impossibility and legal impossibility. Sine qua non, that is the important requirement for invoking section 56. More specifically, I will say here, I am mentioning here 56 part 2. An existence of a valid contract between the parties. The contract is yet to be performed. The contract, after it is entered into, becomes impossible to perform due to fact or law. These are the important requisites of section 56, or you can say essential requirements or components of section 56 part 2, which deals with discharge by impossibility of performance.